5 mistakes that victims make that hurt their injury case. Number 1, giving a recorded statement to the insurance company. The insurance company for the at-fault party is going to try their best to get a statement from you after an injury. It doesn't matter if it's a car crash, slip and fall, or dog bite case. The insurance company will do their best to be as sweet as sugar cream pie to get you to give a recorded statement. And if you do agree to giving a statement, the entire time they're going to try to make you say silly things that are going to hurt your injury case. You could have been going slower, right? If you'd been looking out better, this wouldn't have happened. You knew the floor was slick when you walked in. You know that excited dogs could bite. The insurance company is trying to get you to admit some fault so they can use that against you in order to try to pay you less for your injury case. Never give a statement to an insurance company without talking to an attorney first. Never. There is no exception. Number 2, delay getting medical treatment. This is the big one. Insurance companies are looking to see if they can use any delay in getting medical treatment as a reason to argue 2 different things. That you're making up the injury, because if you were really injured, you would have gone to the doctor immediately. Or, number 2, that the delay is proof positive that the injury is minor. I'm going to give you a little tip. If you're in a car crash, a slip and fall, or bitten by a dog, go to the doctor if you even suspect you might be injured. At the very minimum, send a message to your doctor on the secure app every single doctor has nowadays, so if it becomes an issue, we can show the insurance company you're taking it seriously. The longer you delay in receiving medical treatment after an injury, the harder it will be to get an insurance company to pay you or to compensate you. Don't delay. Number 3, treating medical treatment too casually. What do I mean? It means when a doctor or nurse asks you how you're doing and you say, "I'm fine, I just got into a little car crash." You think you're being polite and having some chit-chat, but the doctor or nurse might be writing down, "Patient reports that he was in an automobile crash, but he is overall fine." Your visits to the doctor will end up being part of your injury case. Anything you say to the doctor or nurse could end up being in the medical records. Be careful of what you say. Tell them what's going on. Tell your medical providers what you're experiencing. Tell them what hurts. Please don't use percentages when describing your pain. Percentages do not come across correctly when medical records are being read as part of the court record. On the second visit, patient reports that he's 80% better. 80% of what? Your best day ever? 80% of when you were 18 years old? What happens when you're 95%? Should a jury really help you get that last 5% when they've been having back pain for the last 5 years? Don't use percentages when describing yourself to medical providers. Instead of using percentages, use numbers. My pain was a 7 out of 10 this morning. This afternoon it's 6. Numbers correspond to the medically accepted pain charts. So don't use percentages, use numbers. And it's 2023 when I'm recording this video. We live in the day and age where every medical provider has secured apps where you can send messages through your phone. I even did a virtual visit with my doctor this past year. When you're doing these things, though, please don't forget that these messages and virtual visits are still part of your medical record and can end up being part of the evidence of your case. So even though these messages and virtual visits don't feel as formal, they are important. Don't forget that. Please do not treat your medical visits too casually. Number 4, trying to be tough. If you're hurting, tell your doctor or nurse. If you don't tell them you're hurting and it doesn't make it into the medical records, well, then it doesn't exist. If your arm and leg both hurt, tell your nurse and doctor that your arm and leg both hurt. If your arm hurts way more than your leg, still tell them about your leg pain. If you're depressed, tell them. If you're having trouble focusing at your job after the crash, fall, or dog bite, tell them. If you're having nightmares about the injury, tell them. Now is not the time to be tough. If you've been injured, you need to be compensated for all of your injuries, not just the worst ones. Number 5, posting on social media. Try not to post about your injuries or your injury case on social media. Why? Because the moment you post something that is inconsistent with an injured person, then that's going to be an effective way for the insurance company to say you're exaggerating your injuries. So you get injured. And while you're still getting treatment, you post the following: "Great day at the park." Guess what? That's going to be used against you. At some point, an insurance company or their attorney is going to say, "Well, sir, you said you were still experiencing pain on April 1st, 2023, but you also posted on that same day, 'Great day at the park.'" What I meant was, all things considering, it was a great day at the park, And they're going to say, well, you didn't post all things considering, so were you lying then or are you lying now? It just gets messy fast. Please be careful posting on social media and understand that anything you post can be used against you. When dealing with an injury case, most people feel frustrated with the process. Please allow the Marc Lopez Law Firm to turn that frustration into compensation. Give us a call, 317-632-3642.